not going to be a cop about it, but yeah. Okay, welcome everybody. Welcome to the panel on abortion law after Dobbs. My name is Sherif Girgis. I'm an associate professor at Notre Dame Law School and very grateful to be asked to moderate an extraordinary panel. I should give credit to Will Bode for picking the panelists, but I would like to think that I would have done as good a job. I could not imagine doing a better job at picking panelists to talk about the very complicated set of issues that were opened by the decision that closed one question, at least for Supreme Court law, of whether there's a constitutional abortion right. A range of constitutional and statutory and subconstitutional questions of all other kinds that have arisen, and our panelists will give you the lay of the land. But first, I was asked, as a matter of housekeeping, to tell you that the Wi-Fi password is all lowercase, courage in action. And also to warn that, unfortunately, one of our panelists, Professor Mary Ziegler, is under the weather, but very graciously, she's agreed to join us by audio. So there won't be anywhere to look, but her voice will boom in the room at the appointed time. I'll just briefly introduce our panelists and then hand it over to them for opening spiels for about 8 minutes or so, and then some discussion among the panel, and then we'll open it up. So please do be thinking about questions that you've got about the topics as we go along. So first, we will hear from Professor Stephen Sachs, who's the Antonin Scalia Professor of Law at Harvard Law School, where he teaches and writes on civil procedure, conflict of laws, and constitutional law and jurisprudence. He's authored numerous articles, essays, and book chapters. He's an elected member of the American Law Institute, an advisor to its restatement of law on the conflict of laws, which will be the focus of his discussion here. He's a recipient of the Federalist Society's Joseph Story Award. He previously taught at Duke and as a visiting professor at Chicago. Before that, he practiced litigation with Mayor Brown in D.C., having clerked for Chief Justice John Roberts and Judge Stephen Williams on the D.C. Circuit. He received his JD from Yale, a first-class BA in philosophy, politics, and economics from Oxford as a Rhodes Scholar, a bachelor's summa cum laude in history from Harvard, where he earned the Sophia Freund Prize. Second, we will hear from Professor Rachel Rebouché, who's the Kean Family Dean of Temple University Beasley School of Law and the Peter J. Liacouras Professor of Law. She's a leading scholar in reproductive health law and family law and has authored many law review articles and peer-reviewed articles in those fields. She's also author of Governance, Feminism, and Introduction, and an editor of Governance, Feminism, Notes from the Field, editor of Feminist Judgments, Family Law Opinions Rewritten, published by Cambridge, and an author of the 6th edition of the casebook, Family Law. In addition, she'll join the 5th edition of the casebook, Contracts, Law and Action, and she recently co-edited a collection of essays for law and contemporary problems on the pandemic's effects on contract law. Dean Rebouché has served as a co-investigator on 2 grant-funded research projects on reproductive health, including one funded by the World Health Organization. She's received her JD from Harvard, an LLM from Queen's University in Belfast, and a bachelor's from Trinity University. And before law school, she worked as a researcher for the Northern Ireland Human Rights Commission and Human Rights Center at Queen's University. Professor Stephanie Barclay, my much-missed former colleague, is a professor of law at Georgetown Law School and a faculty co-director for the Georgetown Center for the Constitution. Her research focuses on the role of different democratic institutions in protecting minority rights, especially at the intersection of free speech and free exercise. Her works appeared or will appear in the Harvard Law Review, the Chicago Law Review, the Penn Law Review, the Yale Law Journal Forum, and has been featured in a number of media outlets, including the New York Times, the Wall Street Journal, the Washington Post. Prior to joining Georgetown, she was twice voted Professor of the Year. She has litigated constitutional cases, including before the Supreme Court, and she served as a law clerk to Judge Randy Smith on the Ninth Circuit and Justice Gorsuch on the Supreme Court. She's a faculty affiliate at the Constitutional Law Center at Stanford, has served as chair for ALS Law and Religion section, and got her law degree from BYU, summa cum laude, where she was Order of the Coif, and she has a PhD, forthcoming PhD, in law at Oxford, where she's a Clarendon Scholar. And then Professor Mary Ziegler, who will join us by audio. and in spirit is the Martin Luther King Professor of Law at UC Davis, where she's an expert on law, history, and politics of reproduction, healthcare, and conservatism in the U.S. from 1945 onward. She's a Guggenheim Fellow and one of the world's leading historians of the U.S. abortion debate. She's written or edited numerous articles and books on social movements and struggles around reproduction, with work appearing in the Yale Law Journal, the NYU and Michigan Law Reviews, the Law and History Review, and the Journal of the American Medical Association. Her 7 critically acclaimed books include, most recently, Dollars for Life, The Anti-Abortion Movement and the Fall of the Republican Establishment, and Roe, The History of a National Obsession, both with Yale University Press, as well as After Roe, which won the Harvard University Press Thomas Wilson Prize for Best First Manuscript in any discipline. And she's got a forthcoming book with Yale on personhood, the new civil war over reproduction. She's advised governors and Congress and had her work featured on ABC, CBS, all the networks, New York Times, The Atlantic, The Washington Post. Before coming to Davis, she was the Daniel P.S. Paul Visiting Professor in Con Law at Harvard and the Stearns Weaver Miller Professor at FSU, where she won several teaching awards. All right, we will start with Professor Sachs.
Thank you very much for that kind introduction. Thank you to all of you for coming and sharing your afternoon with us today. I'm going to be discussing some of the issues that have arisen after Dobbs as a result of conflicting regulation in the states. Dobbs announced that the appropriate constitutional test for regulations of abortion would henceforth be the rational basis test, such that many different state regulations would be possible. And that has produced a lot of conflict of laws issues, which is one of my day jobs. I'm going to talk primarily about a recent case that is filed about a month ago called Texas versus Carpenter in the Collin County, Texas courts. If time permits, I will also discuss a case in the Ninth Circuit involving an Idaho statute. And both of these involve a local statute that prohibits abortion or various transactions related to abortion, and then a question of interactions with someone who is out of state or going out of state to a state where the abortion procedures are lawful. So what happens when we have these different rules in different states? So take Texas v. Carpenter. This is a case involving telemedicine. Ordinarily, telemedicine regulation is governed by the state in which the patient is located. So over Christmas, I got the flu in North Carolina. I tried to have a telemedicine appointment with my doctor in Massachusetts. They said, no, you are in North Carolina. We cannot provide services to you because we don't have North Carolina medical licenses. We have Massachusetts medical licenses. And even though you're a member of our, you're a client of our practice here, a patient of our practice here, if you are physically located out of state, we would be providing services in that other state, so we can't do that. So that's the general rule. Some states, though, have recently enacted a variety of laws, sometimes called shield laws, designed to insulate from other kinds of regulation the practice of various kinds of medical procedures, mainly abortion, but also some involving gender transition and other things. And so under these laws, a doctor in state A, where abortion is legal, is entitled by state A law to provide care in state B, where abortion is illegal. Now, state B may disagree with this. They may say, no, you're engaging in the unauthorized practice of medicine. And so Texas v. Carpenter is a case where that conflict arose. So Texas filed a civil suit against Margaret Carpenter, a doctor in New York, who had prescribed via some telemedicine procedure, it's not entirely clear from the complaint, 2 abortion drugs for a woman in Collin County, Texas. And the drugs were somehow shipped, perhaps mailed to Collin County. In any case, they wound up there. And the patient was later taken to the hospital for internal bleeding, whereupon the biological father discovered the medications at home and that they had been prescribed by Carpenter. The state then sued Carpenter in Collin County Court, seeking an injunction and civil penalties, both for violating their statute on abortion and also for violating their statute on unauthorized practice of medicine. So a bunch of questions that arise here. First, personal jurisdiction. Can Texas make Carpenter show up in Collin County Court? Now, in general, the answer would be yes. Because if you send a product into Texas that may be bought online or something like that, you slap a Texas mailing label on it, you put it in the mail, it goes to Texas, it explodes, causing injury. That is a classic case of product liability where the buyer could sue in Texas. So standard personal jurisdiction doctrine would say, oh yes, Texas can hear this case. Okay, so they're hearing the case. Question 2, choice of law. Can they apply their law, under which abortion is illegal and the practice of medicine unauthorized, as opposed to New York law, where the practices are legal? In general, the full faith and credit and due process clauses have been interpreted in cases like Allstate and Phillips Petroleum to involve a very light touch here. And in general, states can do what they want, so long as it is not so arbitrary and unreasonable as to be sort of beyond the pale. And so Texas surely under that standard could apply its own law in the Collin County case. Now there's an asterisk on that, which is that another line of Supreme Court decisions, typically not under the full faith and credit clause, things like BMW v. Gore or State Farm say that when it comes to punitive damages, or cases like Huntington versus Attrell, when it comes to criminal prohibitions, a state cannot punish conduct that was lawful where it was performed. So New Jersey cannot say the speed limit across the nation is 55, and if you went 85 in Texas, you committed a New Jersey crime. That doesn't work. Due process will stop that. But if you are sending a product into another state and it gets there, that is typically thought of as an act in state B. So if I'm standing in state A, I shoot across the border, the bullet goes across the border, hits someone in state B. That is, black letter law, a state B event, and therefore state B can prohibit that as murder. Even though I never entered state B, I stayed in state A and shot across the border. So it would seem like Texas would be entirely able to apply its own law in this kind of situation. All right, so imagine the case is ongoing. Texas wants to subpoena somebody in New York or get discovery. Well, normally states help each other with discovery, and they have various statutes, sort of uniform acts to make this more feasible. The shield laws say no. Shield laws say we won't help. Nobody is obliged to help. Our courts won't help. No public officer who gets money from the state will help. We're not going to help at all. Now, that's something the full faith and credit clause really doesn't do anything about. So full faith and credit clause has been interpreted to require enforcement of judgments, but it does not require enforcement of subpoenas, enforcement of discovery in another state. They cannot necessarily get another state to help out with document production requests, et cetera. Now, in theory, Texas could impose various penalties for not doing so, but they can't actually make the officers of New York do stuff in New York to help them get information. All right, well, that leads us to the fourth question, the end game. Suppose that Texas says, you lose Carpenter, or suppose Carpenter just defaults. She's subject to personal jurisdiction, but doesn't show up. And Texas issues a default judgment. Can it enforce that judgment? Well, normally under the full faith and credit clause, judgments from one state have to be enforced in another. But there is an exception for what are called penal judgments. Typically, that's criminal prosecution, but it can also include certain kinds of civil penalties that are done for the benefit of the public and not as a matter of private mine and thine kind of litigation. So usually the rule is that a state is not required to enforce a penal judgment, including a civil judgment from another state. And to the extent that Texas is seeking civil penalties for violation of their unauthorized practice rules, this would be a classic civil judgment. So it seems like Texas can do whatever it wants in its courts, but it can't necessarily force New York to enforce those judgments, and under the New York Shield Law, New York won't. So what could Texas do? Well, maybe Carpenter has assets in other states that would enforce it. Maybe she uses a bank that also has branches in Texas, and Texas could grab money from the bank and sort of garnish their assets because they owe her money somewhere else. I mean, there are all sorts of weird things that might then happen. Fifth issue, the New York law provides for a clawback. It says that anytime somebody sues about abortion, and it would be against New York law, you can sue them back for treble damages. This is probably not okay under the full faith and credit clause. There are some interesting issues that I'd be happy to talk more about in Q&A. But there's also very weird wrinkles because the state of Texas has sovereign immunity. So Carpenter can't sue Texas in New York's courts. She could try suing the officers of the state of Texas, the lawyers who signed the papers. So are they protected? Do they have a constitutional right to do what was lawful in Texas, such that New York cannot punish them for conduct lawful in the state where it was performed? That issue, as far as I know, has never been litigated. There's only a few cases on clawbacks, mainly involving foreign countries, and in general, U.S. courts don't care what the foreign countries think, but they do tend to care what other states think. So very interesting questions are going to arise. Last comment I want to make, because my time has already elapsed. A better strategy, perhaps, for states in Texas's position might be individual litigation. So if the biological father had sued Carpenter in Texas, a number of things would have happened. One, any judgment would not have been a penal judgment, which means the full faith and credit clause would demand its enforcement in New York courts. Two, they could raise the clawback issue as a compulsory counterclaim. So they could say, you have to make your clawback arguments in Texas, where they will lose, because if you could make them, I'm not sovereign immune, so you could sue me, and so you have to sue me arising out of this transaction. Three, they could go to federal court. There is no original jurisdiction in district courts for state versus citizen of another state cases. There's original jurisdiction in the Supreme Court, but they never hear those cases. They always deny leave to file. But there's nothing for district courts. But an individual can sue another individual in diversity, go to federal court, and then you get whatever discovery you want. There's no way that New York can resist a federal subpoena or federal discovery. And so there might be a lot of advantages to individual suits that are permitted by state laws rather than public enforcement. So I'll stop there, and apologies for going over time.
Dean Rebouché.
Thank you. Thank you for inviting me to speak, and thank you for that introduction to shield laws. I've been asked to talk about the proliferation of mailed medication abortion. And those of you who have studied this issue, the issue of abortion since Dobbs, know that 19 states now ban abortion before viability, some of them from the earliest moments of conception, some before 6 weeks. At the same time, 21 states have passed the shield laws that Professor Sachs has just described, though in my 8 minutes, I'm going to spend a little time talking about the provisions that are relevant to the Paxton-Carpenter litigation, the 8 states that define care, legally protected reproductive health care, quote, regardless of the patient location, which, as Professor Sachs notes, is a turn from how we typically define the location of care, which is where the patient is. But let me start with a focus on medication abortion, its regulation, quickly its uptake and the uptake of mailed medication abortion pills, how that's shaping the legal landscape post-Dobbs, and how that has proliferated on the ground. I think that's the task that I've been given for today, before talking a little bit about some of the litigation that was before the Supreme Court this term. So just by way of background, for those of you not as steeped in abortion law as some of us on the panel, medication abortion is a 2-drug regimen that ends a pregnancy 10 to 12 weeks of gestation. The growth of virtual clinics, which offer medication abortion through telehealth, follows a court decision that temporarily enjoined the FDA's restriction on the first drug in a medication abortion, and that's mifepristone. Of the drugs regulated by the agency, and the 16 with the same safety restrictions as mifepristone was the only one that you had to pick up at a healthcare facility but did not have to take in the presence of a provider. In December 2021, the FDA announced that it would lift that rule and permit as well certified pharmacies, along with certified providers, to dispense mifepristone. So with the removal of the in-person restriction, mifepristone, along with misoprostol, the second drug in a medication abortion, has now been mailed to patients as prescribed, mailed before 2021, but the uptake is significant. So take, for example, the proliferation of the virtual clinics I just mentioned. You can think about how abortion on demand, one of the largest US-based virtual clinics, operates. Just out of my own curiosity, how many in this room have heard of the online clinic Abortion on Demand? Excellent. Thank you, Jonathan. So in 22 states, Abortion on Demand prescribes medication abortion up to 10 weeks of pregnancy as approved by the FDA. Only for people aged 18 and older, as not to run afoul of parental involvement restrictions. And the entire process from counseling to the receipt of abortion bills takes about 2 to 5 days and is about $300 to $400 less expensive than a clinic-based procedure. As I said, this is not an entirely new phenomenon. There were investigational studies that studied the efficacy and safety of mailed medication abortion, but one group, in addition to Abortion on Demand that bears mention, is Aid Access, which is a group that works with providers to mail medication abortion across the country, including to states where abortion or teleabortion is prohibited. And of course, people order pills online without aid access or without the help of a virtual provider. So I think I don't tend to talk about this subject without noting that, of course, not all people who seek abortion are candidates for medication abortion, let alone mailed medication abortion. It depends on various forms of privilege, a smartphone, a stable internet connection, an uncomplicated pregnancy. And for people who seek to terminate a pregnancy later, past 10, 12, the first trimester of pregnancy, they continue to need the resources of a brick and mortar clinic. Nevertheless, my mailed medication abortion has become one vehicle for delivering care across state lines, no matter where one lives. So there are numerous, and how much time do I have left? Sorry to break the flow. 5 minutes? 3 minutes? Okay. So efforts to curb access to pills, they have been at the heart of a number of strategies, and one such strategy was present in a Supreme Court case decided this summer. Alliance for Hippocratic Medicine sued to remove mifepristone from the market, arguing it was unlawful for the FDA to approve the drug in 2000. Judge Kaczmarek, a federal district court judge in Amarillo, agreed. In April 2023, the district court issued a preliminary injunction suspending mifepristone's approval. On emergency appeal, the Fifth Circuit stayed the district court's suspension of mifepristone's approval, but affirmed the injunction suspension of the FDA action past 2016, which included the lifting of the in-person dispensation requirement. The Fifth Circuit went on to hold that plaintiffs likely failed to timely challenge the 2000 FDA approval and likely failed to plead an injury regarding mifepristone's generic approval in 2019. However, the court found that the agency's changes to the regulation of mifepristone after 2016, including the lifting of the in-person pickup rule, was unlawful. So before a unanimous Supreme Court, Alliance did not have standing to bring its claims because the organization or its members could not show that the FDA's actions caused them injury. But Justice Kavanaugh, who wrote the majority opinion, stated, quote, "It's not clear that no one else would have standing to challenge the FDA's relaxed regulation of mifepristone." So I think that I was asked to talk about this case. That's the chief reason to talk about it. But two, it's also that standing aside, the core issues of this case are not resolved. And I think we've already seen the ways in which Alliance arguments, along with its call to revive the Comstock Act, which Professor Ziegler will talk about, they're not going anywhere. And in fact, I think it's worth mentioning that the claims that we saw in Alliance briefings of track arguments that pre-exist the Alliance for Hippocratic Medicine litigation by years. You can look to, for instance, a February 2022 pre-Dobbs report by the Family Research Council entitled "The Next Abortion Battleground, Chemical Abortion," in which the report describes medication abortion as a violent regime that results in profound dangers to people and is uniquely traumatic. Maybe in Q&A we can talk about how some of those efforts to impede the proliferation of medication abortion have arisen in states like Louisiana, classifying medication abortion drugs as dangerous controlled substances. So at the same time, in my last couple of minutes, I think it's worth teeing up that efforts to impede medication abortion, including male medication abortion, meet efforts to expand its reach. And, it's also, for those of you who study this issue, it's worth noting that in the year after Dobbs, the average number of abortions in this country went up, and that is in part because of mailed medication abortion. So chief among those efforts, shield laws, as Professor Sachs described. I won't go through the ways that shield laws try to protect providers' licenses and malpractice insurance rates. Happy to give a lot more description in our conversation. He mentioned the ways that shield laws attempt to thwart investigations, discovery, both criminal and civil. And the ways that they shield providers from extradition so long as a provider or those who help the provider are not fleeing from justice in contravention to Article 4 of the Constitution, the clawback provisions, and finally, the 8 states, Massachusetts, New York, California, Colorado, Washington, Vermont, Maine, and Rhode Island, who incorporate those measures, but also, as I said, define protected reproductive health care regardless of patient location, which is, you may have read in popular media, is one of those have become the sites, particularly New York, where Dr. Carpenter resides and practices law and has a license. That language of shield laws has been one way in which providers have mailed medication abortion to states across the country, including states like Texas, where abortion is banned at conception, with exceptions.
Great. Sorry. Thank you so much. Professor Barclay.
Thanks, Sherif. It's a treat to be on this panel and to get to learn from experts in this area. I was asked to speak about issues related to abortion at the intersection of First Amendment issues, so religious exercise and free speech issues. The first case I'll talk about is Bella Health and Wellness versus Weiser, coming out of the district court in Colorado. So we've been hearing a lot of interesting remarks about medical abortion and the way that you can receive these two different, how would you say it? You're receiving the pill at two different moments, right? Two different junctures.
So you receive mifepristone, that's one pill, and you take that, and then 24 hours or 48 hours later, 4 pills, that's misoprostol.
Yeah, okay. She explained it much better than I could. That's relevant because some women in those 24 hours change their mind, and they decide, I don't really want to go through with this abortion. That was a bad idea. Some women have also come forward, and there was evidence in this case that they were pressured to take the first portion of the medication. There was coercion involved. There was a boyfriend who was, making life difficult, and that really wasn't the course of action that they wanted to engage in. And so in Colorado, there's a medical center, and one of the plaintiffs is an OBGYN who will prescribe progesterone in that window of time in order to help reverse the effects of abortion. That first tranche of medication may not be successful on its own anyway. There's a statistical, it's something like 20, sometimes to 30% of patients, if they only take that medication, the abortion won't be successful. And so the progesterone increases the chance that the woman won't have an abortion. Progesterone is also prescribed for women if they have had miscarriages or they're at risk of miscarriage, or there's a preterm birth risk for the woman. And so there are a lot of different ways in which doctors are prescribing progesterone, many of them off-label. So Colorado recently, in 2023, passed a law called SB 23-190 that makes only the particular use of progesterone illegal in the context where a woman would like to reverse the abortion. I think this context is interesting because it turns on its head a lot of the typical rhetoric and arguments we hear about choice for women, their autonomy, their ability to make decisions with informed consent with their provider. And this particular law seems to flip a lot of that and not give a lot of weight to the woman's choice and desires and the advice she's receiving from a medical provider. So Bella Health and Wellness sued and sought a preliminary injunction, both arguing that this violated their religious exercise to preserve life and also their speech rights and how they were counseling their patient. The legislation specifically says in the text of it that these anti-abortion centers are ground level for a well-coordinated anti-choice movement. Some of the legislators also called these medical clinics fake clinics. Part of that is relevant for how the district court ultimately ruled in this case under Smith. So what the court said is that because there were secular exemptions, so Colorado is willing to allow doctors to continue to use progesterone for other reasons, to stop miscarriages, to stop preterm births, but is trying to prevent progesterone just to stop abortions, that is not generally applicable under Smith, and so that triggers strict scrutiny. The court also said that Colorado seemed to be aiming at these sorts of religious pro-life medical centers. It was the object of Colorado's action, which meant that this law was not neutral. And the court also said that it could have failed Smith under a third basis, and that was that the law allowed a mechanism for individualized exemptions, and so it wasn't generally applicable on that basis either. None of that meant it was the end of the case. It just meant that we then move on to see whether or not Colorado satisfied strict scrutiny, and the court here found that they barely made a passing attempt. They had very weak evidence that there was really some sort of medical risk different from any of those other activities. And so there is a preliminary injunction in place that protects Bella Health, but I think it's interesting to keep in mind that that preliminary injunction is narrow. And so other providers that don't have a religious objection to helping women reverse their abortions, but just think that that's good medicine, it's in the best interest of the woman and her autonomy and her health, they're unable to use progesterone right now in Colorado for those purposes. Another case that I'll talk about briefly is the individual members of Medical Licensing Board of Indiana versus anonymous plaintiffs. And this was a case that I had the privilege of working with my much missed former colleague, Rick Garnett at Notre Dame, and we filed an amicus brief in this case. So this is sort of the flip side of the Bella Health context, where you have a group of plaintiffs and association representing Jewish women who argue that in some contexts, their religious exercise would require them to obtain an abortion. So there are questions in that case about associational standing. I'm not going to get into any of those. I think the strict scrutiny aspect of that case is the most interesting. Indiana has passed a law that says life begins at conception, and so ending life will constitute abortion, but they have some exceptions to that requirement when it comes to things like in vitro fertilization, disposal of those, the material related to that, the fetuses for that, and they have exceptions for the health of the mother, rape, or fetal abnormalities. And so the plaintiffs in this case have argued, because you have exceptions to this rule, then that means you don't really have a compelling interest in passing this law, and so it should fail strict scrutiny. And the lower appellate court agreed. This was, they requested the Supreme Court in Indiana to hear this case, and the court essentially decided not to, because they said there's very few women who are actually affected by this right now. There's not evidence that the plaintiffs in this case are currently pregnant or seeking an abortion. They would rather hear the case on a full record. There was one dissent from that decision. So this case is still pending. It's at the trial court right now. Let me tell you why I think that the lower appellate court, though, got it wrong. Let me start by what I think is just some deductive reasoning in this case. So the Supreme Court has said in a case called Cruzan that there can be no gainsaying the state's interest in protection and preservation of human life. So if there's any government interest that is compelling, saving a human life has got to be it. In Dobbs, the Supreme Court made clear that states now have the right to define human life as beginning at conception if they wish to, or at different points, but as early as conception, they can say that that is when human life begins. Indiana has done that. They've done that in their law, and therefore, I think it's pretty straightforward that Indiana has a compelling interest in protecting what they have defined as human lives and protecting them. So the plaintiffs are arguing that the existence of exemptions means that this law should fail strict scrutiny. That's not how it normally works. Exemptions mean that we have triggered strict scrutiny, but now we have to ask questions about, are there other ways that the government could accomplish its compelling interest? Is the government really advancing its compelling interest? That's usually what's at stake in the strict scrutiny cases. So if we go back to Bella Health, for example, it is not as though the Bella Health medical providers are saying, yeah, we really don't care about the health of women and we would like to cause them to hemorrhage, thank you very much. That's our religious exercise. That's not what they're saying. They're saying we just disagree that that's what providing progesterone to these women would do. We don't think that the evidence supports any sort of risk you government are talking about. That's why we prescribe progesterone to women in all sorts of contexts. We actually think their health would be benefited if we reverse the abortion according to their wishes. That's usually what's the question in other contexts, like the COVID litigation, which the plaintiffs cite in this case. So in the COVID context, when religious groups were asking for religious exemptions, the dispute was about whether or not their actions would in fact harm human life, or whether they could meet socially distanced in churches with masks on in ways that would still be safe for human life. The abortion context here is unique because the plaintiffs have conceded there is no less restrictive means for the state to protect the human lives that it wishes to protect. And by definition, every additional abortion that the state allows to move forward under the state's definition is ending another human life. And I think this context is unique because every human life that the state is protecting arguably is advancing a compelling interest. So those are some of the reasons why Rick and I argued that the Indiana Court of Appeals got it wrong. And if the Indiana Court of Appeals rule remained the law, that would mean that if the Aztecs moved into Indiana and said they had a religious exercise in human sacrifice, there's no compelling interest in ending that sort of practice because we allow people to kill each other in self-defense. We end life support. There's a lot of contexts in which we don't protect human life uniformly, and that doesn't mean, it shouldn't mean it, and has never meant in any other case, that we can't advance it in particular contexts where the government thinks that that's a priority. I'll go ahead and end there.
Thank you, Professor Barclay. And then finally, Professor Ziegler, if you can hear us.
Hey everyone, I'm going to be kind of haunting you, which makes it appropriate that I'm discussing the oldest law of the ones, I think, on tap today. I've been asked in 8 minutes to cover constitutional fetal personhood, wrongful death suits, which I think Professor Sachs already alluded to as a potential path. They're one that pro-life groups in Texas and elsewhere are already exploring. And then finally, the Comstock Act itself. So if we're thinking of the last era of litigation around abortion as sort of centered on Roe or the abolition of Roe, depending on your political point of view, the new era, I think, really is going to be about, in some ways, either the restoration of some kind of Roe-like standard for progressive movements or the establishment of some kind of fetal personhood standard for people in the pro-life movement. It's interesting to note this is both new and not new. Since the 1960s, there have been arguments for various forms of 14th Amendment fetal personhood. They've varied quite a bit. So the movement in the 60s would not have really been making anything that we could designate, as often at least, be making anything we would designate as an argument rooted in originalism, whether sort of Steve's version of originalism, original public meaning originalism, original intent originalism. There were instead, I think, efforts on behalf of people in the movement to fit arguments for 14th Amendment personhood into then dominant constitutional paradigms. For example, arguing that the unborn child should be qualified as a suspect classification, or that there was prejudice, for example, based on residence in the womb or age. Over time, of course, the relationship between the conservative legal movement and the pro-life movement has grown much closer, and originalism in various permutations has grown more influential in the federal courts. And along with that, we've seen a rise in originalist pro-life, or at least personhood adjacent scholarship by scholars like Joshua Craddock, John Finnis, and Robert George. And we've also seen a more open embrace of personhood on the movement side, too, as a kind of new great white whale or strategy goal, as embodied in a new North Star letter signed by a variety of leading groups and activists. This strategy recognizes that the recognition of 14th Amendment personhood in the short term in the US Supreme Court seems unlikely, and that a kind of longer term campaign involving stepwise changes, the recognition of fetal personhood or fetal rights in various combinations in state laws should come first. We are starting to see signs of this approach being followed already. We're seeing state laws calling for the recognition of personhood across all legal domains. In Tennessee and Oklahoma already filed this term. And we're also seeing more stepwise changes to the identification of fetal life in places like Texas, where a fetal child support bill has been filed. Personhood is also going to play a role in some of the cross-border conflicts that Professor Sachs previewed for you. Texas Right to Life is currently recruiting biological fathers to sue a range of actors, not just doctors who are mailing pills into states, but abortion funds which facilitate cross-border travel for abortion, donors to those funds, internet service providers that host websites offering information about abortion, the websites themselves, and a variety of other actors deemed aiders and abettors. State legislation on this point is defining aiding and abetting more broadly to accommodate these kinds of proposals. The wrongful death suits, of course, will raise conflicts of law questions, particularly as they target a range of actors who have arguably fewer contacts with the states that prohibit abortion than the Carpenter case does. But they're also designed to advance the principle of personhood by assuming, as the Alabama Supreme Court did in interpreting that state's wrongful death of a minor act last February, that a fetus or unborn child is a person for the purposes of that law. There are also interesting questions about whether there will be conflicts of law issues arising around personhood, particularly around the question of domicile, where a state prohibiting abortion may see a particular abortion as affecting more than one person, that is to say, the unborn child and the patient seeking the abortion, whereas a state protecting abortion may see only one person on that side of the aisle and only one on the other, like a provider and a patient. Some of these suits will also undoubtedly contain Comstock Act claims. The Comstock Act, for those of you who have been fortunate enough not to have to study the Comstock Act as much as I have, is an 1873 obscenity law that was originally introduced by its namesake, Anthony Comstock. The Comstock Act is much broader than a provision on abortion. It contains, for example, even in the very clause mentioning abortion, discussion of other items for indecent or immoral use. It had emerged as a candidate for a kind of short-term potential path to a national ban for lawyers in the pro-life movement who recognized, I think correctly, that a constitutional personhood ruling in federal court might not be achievable in the near term. I credit this as a historian to Jonathan Mitchell, the former Texas Solicitor General, who argues that he came up with this idea of Comstock as a potential door to prohibiting abortion before Dobbs was even issued. His argument relies on the text of the statute, which refers in pertinent part to items designed, adapted, or intended for producing abortion. This is a modification of the original text, which referred to items for the prevention of conception or the procuring of abortion or other items for indecent or immoral use. Mitchell and other attorneys, including attorneys from the Alliance Defending Freedom, have settled on an interpretation that this language bars the mailing or receipt not only of abortion pills, but other abortion-related paraphernalia. Although certainly the focus of the use of the Comstock Act in the movement since 2022 has been on abortion pills. There are different ways we could see the Comstock Act emerge as a major issue in litigation. The movement, I think, has pinned its hopes primarily for obvious reasons on the possibility that the Trump Department of Justice will begin enforcing the Comstock Act, or at a minimum withdraw a memo issued by the Office of Legal Counsel under the Biden administration that relies heavily on cases from primarily the 1930s, 20s, and teens, interpreting the Comstock Act not to apply to all abortion-related mailings, but only to those done with an unlawful purpose. I have been asked innumerable times what I think the Trump Justice Department will do on this score, and my honest answer is that I have no idea. My sense from people in both movements with whom I'm speaking for various oral history projects, is that they don't necessarily all know either. So I think some of this is still very TBD. For that reason, of course, there are lots of efforts to get the Comstock question to the Supreme Court that don't involve direct DOJ enforcement as a spark. These include an ongoing or an effort to resurrect the suit against mifepristone that's been brought as an amended complaint in district court in Amarillo by the attorneys general of Kansas, Missouri, and Idaho, who feature Comstock Act claims more prominently, in my view, than the original plaintiffs in the Alliance Defending Freedom case did. There's also ongoing litigation involving the so-called sanctuary cities for the unborn movement, with which Mitchell has worked quite closely. There's litigation of the furthest along litigation in New Mexico involved two cities, Hobbs and Clovis, and two counties that passed ordinances requiring abortion clinics to obtain special licenses, known as abortion licenses, to comply with the Comstock Act, and imposed various penalties or created particular private enforcement mechanisms for those who violated the provisions. The New Mexico Attorney General challenged these ordinances in an emergency mandamus action before the New Mexico Supreme Court to have the ordinances declared void and enjoin their enforcement. He argued that the local ordinances were preempted by New Mexico state law, and that they violated New Mexico state constitutional provisions on equal protection, due process, and privacy, as well as the state's Equal Rights Amendment, which the state court had already applied in the context of abortion. This case, on the other side, featured arguments by the Alliance for Freedom and Jonathan Mitchell. The New Mexico Supreme Court, in a decision earlier this week, declined to reach any question about federal preemption or the Comstock Act, instead holding that the local ordinances were both expressly and implicitly preempted by state law. They also declined to reach the state constitutional questions. Mitchell was elated by this result and is hoping that it can be a springboard for federal litigation, that there is now a conflict between state and local law and federal law, in his view, that would justify federal court intervention. At the same time, he's not relying exclusively on the New Mexico litigation. There are ongoing efforts involving other so-called sanctuary cities to initiate litigation of this kind. Many of the ordinances that are introduced by the movement, at least in states where abortion is protected, feature the Comstock Act pretty prominently. And this is true as well in states that recently, in the last, at least in 2023 or 2024, passed abortion protecting ballot initiatives, including in states like Missouri. So the goal is to generate as many of these conflicts as possible to maximize the chances of a case ultimately ending up before the Supreme Court one way or another. This will then, of course, generate another round of litigation about whether Mr. Mitchell's interpretation of the Comstock Act is correct. We have reason to believe that Justices Alito and Thomas are sympathetic to it, at least based on questions they asked in oral argument during the Alliance case. We know very little about what the other justices think. There may also be questions raised about the constitutionality of the Comstock Act. But again, a lot of this is very novel. I can say as someone who's a historian of this stuff that people would mention the Comstock Act primarily in the context of laws one no longer thought about. So recent litigation on these subjects is there with respect to its provisions on obscenity, but on the provisions that we're discussing now, there's relatively little guidance. So I think, as is the case with a lot of what we've been discussing today, we're dealing with a lot of messy, complicated issues on which courts have not offered a lot of light. And that makes this area of law, of course, interesting, which why we're having a panel, but also very difficult to predict ahead of time. And I'll stop there.
Thank you very much. I did have a few questions, but I first want to give the panelists a chance to react, offer follow-up thoughts of any kind to anything that's been discussed so far.
Can I pause
Sure.
pose a
Yep,
couple
go
questions? I'd love to hear from Professor Sachs, to your point about jurisdiction. If you're making the argument for Dr. Carpenter that there is no jurisdiction, Texas does not have jurisdiction in Collin County over her, what are the arguments that you would make? And then for Professor Barclay, I'm curious too, that the percentage of abortions that can be reversed is quite contested. So many have argued that mifepristone ends a pregnancy in well over 95% of cases alone, and then it's misoprostol that clears the uterus. And so I think it's a fascinating conversation, particularly in terms of your amicus, how you grapple with the contestation of facts that different organizations and groups have published and see very differently. It's something I think quite a lot about, so I'd be very interested in how you wrestle with that idea.
So the question is what, in light of the fact that sometimes
So
pregnancy...
I think that if you read a Guttmacher report, it has a very different characterization of abortion reversal. My point is not to say they're right and that another is wrong. But my question is, when you are at the crossroads of making an argument in which underlying facts are contested, how does that figure into the legal argument that you advance? It's a question I think is really interesting for medication abortion generally, which is why I'm really drawn to the report that I cited.
Professor Sachs, and then Mr. Barclay.
So what I would say, and I was just looking up the reference here now, I would advise Carpenter, this is not legal advice, to put, all of her efforts on Justice Gorsuch's duck decoy hypothetical from the Ford Motor Company case. If any Civ Pro folks in the room are nodding along.
Not much of a reaction in the room.
Yeah, exactly. I mean, that's like, you would think a crowd like this, we were like, oh yeah, the duck decoy hypothetical. In general, I'd say, look, you're just going to lose. In general, I would say what I teach my students is black letter law, that if you buy a product from an out-of-state manufacturer or out-of-state provider, and they slap a Texas mailing label on it, and you give them your address, and they ship it to you, and it blows up, and it causes injury, they can be sued in Texas. Like, you can file suit where you get injured. There's some discussion in the Ford Motor case of, well, what if it's this one unusual sort of isolated sale case? But even then, the isolated sale language is coming from cases involving stream of commerce where you gave the product to some other distributor or sold it to someone else and somehow it wound up in New Jersey. But the cases of direct shipment where you knew it was going to Texas and you sent it to Texas, it's a really easy minimum contact story to tell. I don't think you can get out of personal jurisdiction there. The question is whether it matters, because at the end of the day, if Texas awards a judgment against you, how are they going to enforce it? Because New York's not going to enforce it. New York doesn't have to enforce it under the full faith and credit clause. It's a penal judgment, excuse me. The real issue is whether any other state will have it, or whether you have any assets in Texas, or you have any assets with institutions that are subject to jurisdiction in Texas and who could be sort of garnished on your behalf. So if, Merrill Lynch is subject to jurisdiction in Texas or something, they could go after that. But that would really be the biggest question for me, is what can Texas do with the judgment? I think you're absolutely subject to personal jurisdiction in Texas under current doctrine.
Professor Barclay?
Yeah, so I think it's an interesting question about how effective is that first round of treatment, and what do we do about, more specifically the point you're asking about, what do we do about the empirical debate surrounding that? Part of the issue, I think, is that the court was less focused on is that necessarily going to be successful on its own, and more focused on what it thought was the more likely candidate for the government's compelling interest in that case, and that is, well, will giving progesterone after that first round hurt the woman? Has the government provided evidence that then prescribing progesterone, if the woman has changed her mind, is going to be detrimental? And they really hadn't. There really wasn't evidence that they were able to marshal in any sort of rigorous way that progesterone would cause severe consequences, which is why they allow progesterone in lots of other non-abortion contexts. Tell me if you're aware of a report that says otherwise on that, but I think the evidence is pretty inconclusive about saying that progesterone is going to be harmful in that context. But to your other point about the success of abortion in that context, part of what the government did try and argue is, well, we don't know, and so we shouldn't use off-label drugs when we don't know if it'll be successful or not. And then the court said, okay, well, if that's your interest, then you're just being wildly under-inclusive, because we allow doctors to prescribe off-label drugs in lots of contexts where we don't have absolute verifiable evidence that for sure this is going to be successful or it's not, or without it, it'll be successful, or with it, it won't be. And so your lack of even-handedness here means that you are triggering strict scrutiny.
Any of the other panelists want to make any points or raise any questions? Professor Sachs?
So I guess the one question I would have for Professor Ziegler floating in the ether is, so the New Mexico court decision I thought was very interesting, and it seemed to go out of its way to make very clear, we think this is an adequate and independent state ground, so Supreme Court stay out of it. And I guess my question is, what do you make of that part of the opinion, and do you think that that will insulate it from Supreme Court review? And in particular, are the limits on municipalities effective even if the state law is partially preempted by Comstock? So the state says municipalities don't regulate this stuff. And according to the municipalities, the state law is permitting things that Comstock forbids. But I guess it would be possible for a state to say, well, municipalities, even if this stuff is illegal under federal law, we don't want you super adding to that. And so is that how the state laws are framed, such that they would have their effect regardless of whether they're actively trying to license something that Comstock prohibits? Or do the state laws just say, we give a state right to X, and maybe if there's a federal prohibition on X, that state right disappears?
Yeah,
I don't
thanks.
know if
I'm
I was
enjoying
unclear in saying that.
No, yeah, I think so. I'm enjoying this sort of appearing like this. I think being like the ghost of Christmas past is going to be my new normal. Yeah, I mean, so the origin story of that part of the New Mexico Supreme Court's opinion is just that that's what the Attorney General asked them to say, right? There was a deliberate effort to focus exclusively on state law issues, to insulate the ruling from Supreme Court review. Like, that's not there by accident. As to whether it'll work, I mean, now I'm going to put on my historian's hat and just say it depends on the Supreme Court's appetite for taking on the Comstock question. I mean, this is a door that the Supreme Court can walk through if it doesn't really want to deal with this right now. I don't know if the court has an appetite for dealing with the Comstock Act or not. Pretty clearly during the Alliance litigation, a lot of the justices did not particularly seem excited about taking up the question. Maybe that changes now. I don't know. So it's a little hard for me to predict. As for the sort of dynamic between federal preemption, state preemption, and municipal preemption, it would depend in large part on one, how broadly or narrowly the court interprets the Comstock Act. I think Mr. Mitchell's argument is that the Comstock Act would effectively shut down all abortions because all abortions involve some item placed in the mail or common carrier, with, I guess, rare exceptions in which you're in a state that manufactures the relevant items in state and doesn't put them into interstate commerce at all. If the court were to interpret the law that broadly, and there were to be no way to sort of have local materials used for abortion, there could be a pretty, I think, major conflict between federal law and state law. the focus, to date at least, of most efforts within the movement to use the Comstock Act has been on abortion pills. In theory, some of the statutes we're talking about, like New Mexico's health freedom law, apply more broadly than to just abortion. That law in particular applies to gender affirming care. Some of them apply to IVF or contraception or a variety of other things. So it's conceivable that there would be areas where state law would conflict with the municipal ordinances and not with the Comstock Act, but that would of course depend, I think, on the state law in question. And there is a sort of, there are a lot of these suits potentially being generated in a variety of states with very different laws, right? Some of them state constitutional measures like Missouri's ballot initiative, some like the Health Freedom Act in New Mexico. So it's hard to generalize, but I think that there'd be some possible scenarios where that could be true.
Professor Barclay, you had a point on this?
I just wanted to very briefly note something that Steve and I both ran out of time to talk about. That is a law that was passed in Idaho that criminalizes procurement of an abortion by recruiting, harboring, or transporting a pregnant minor to receive the abortion. And the Ninth Circuit recently upheld most of that law, but had concerns and struck down and then severed the recruiting portion of it because that deals with expressive speech sorts of conduct. And so this is a point Steve made when we were discussing, but part of the court's reasoning there was, well, you could obviously have protected speech opposing abortion or doing the sort of opposite thing of recruiting, so that must mean that speech is protected if going the other way, if you're recruiting someone to obtain an abortion. And that's not usually how you think about speech if it comes to like speech that's aiding criminal conduct. So just because you could speak, as Steve pointed out, defending someone from being killed doesn't mean that the opposite is true, that you could speak, say, hey, we should really go kill that guy. And that, there's a reciprocal sort of principle that must adhere because one of those speeches is aiding criminal conduct and the other is not, and the Ninth Circuit didn't really grapple with that particular issue.
Mary, I have a question for you. I keep looking at the ceiling.
Yeah, I know. I'm into this. This is great. I got it in the stomach.
So I have a question for you, and then you should also use it as an opportunity to ask or raise any other points you wanted for the panel. And that's whether in your research into the personhood issue, you have found people talking about what they expect to happen the day after a personhood ruling. So we know for sure that it would mean that Congress, under Section 5 of the 14th Amendment, can legislate on the issue, but there's probably a very good argument for Congress being able to do that anyway under the Commerce Clause. We know that courts can't compel legislatures to pass laws, and they can't compel prosecutors to bring prosecutions under existing laws. So is there a game plan for how concretely a personhood ruling would have impact on the ground over and above what political actors were or weren't already willing to do?
Yeah, I mean, I think the best way to characterize this is that there's a debate. And unsurprisingly, if you think about personhood has been a goal of the movement for over a half century. And in that window, there have been a lot of different perspectives on what recognizing personhood would require and permit. And that's still true. So I think, and my understanding, and this is from interviewing people for my research who are currently working on this, there is an argument that liberal state abortion laws would be unconstitutional insofar as they protected other persons in the context of homicide, but didn't accord those same protections to unborn persons. The tricky question then becomes whether those states, and indeed all states, would have to apply prohibitions on abortion as they do prohibitions against homicide. So, for example, there are no exemptions for punishing women in homicide laws, like there's no infanticide exception for women, there's no infanticide exception for women killing domestic abuser, right? I mean, there's no exceptions in homicide laws beyond the kind of, necessity, self-defense, the sorts of things we're accustomed to. My understanding is that that is a subject of robust debate. There is a contingent of lawyers who identify as abolitionists who argue that equal protection in such a situation would require that women be punished for abortion too, and evenly, as would any other defendant who's culpable. There are others who argue that, of course, there are other exceptions to in homicide, or not exceptions exactly, but scenarios where we allow for someone to be punished more or less harshly depending on the identity of their victim. So, for example, if you murder a law enforcement officer, in some instances, you may be subject to elevated penalties. So, for example, Josh Craddock, in my conversations with him, said that it would be entirely possible for states to punish people less for an abortion than they would for another homicide-related offense. And I asked him what would happen if a state tried to exempt an entire category of defendant from any sort of punishment whatsoever, like women, as many in the pro-life movement have long wanted to do. And he said that would be more constitutionally tricky. So the lay of the land, as I take it, is that there's a lot of debate about what personhood would require legally. And that's also true because, of course, all of this discussion so far has sort of proceeded on the premise that personhood is going to be most relevant in the context of abortion, which is, of course, why it's become so salient. But if, personhood begins at the moment of fertilization, that would have implications potentially for in vitro fertilization too. As the Alabama Supreme Court's ruling kind of raised in February, it would have implications for other areas of law where the word person appears. And so in the 1970s, when there was a robust debate about a human life amendment, and that was actually something that seemed politically plausible, which is, of course, so not true now that it got dropped out of the Republican Party platform, which is saying something in 2024. At that time, there were people in the movement who argued that recognizing personhood would have implications for various kinds of welfare policies, expanding benefits for pregnant women, et cetera, et cetera. So I don't think we've fully worked out what the kind of day one or even day 30 or day 365 version of personhood looks like, in part because I think certainly there would be disagreements between people, across the ideological spectrum on questions of abortion. I think there are also disagreements on either side of the debate on precisely what personhood requires. And some of that is because I think Dobbs came quite quickly and changed personhood from something that was kind of the aspirational kind of moonshot into something that could be achievable at the state level in the near term, and maybe even something achievable at the federal level in the not so distant term. And I think that's why we're seeing a lot of these kinks still being worked out.
Great. So and then one question for both Dean Rebouché and Professor Sachs. In the lead up, well before Dobbs, one characterization of what would happen after Roe by many of the people who wanted Roe to go was, it'll just send the issue back to the states. And one way that could fail to be true is if it gets nationalized either through a statute or through a personhood ruling that then has further effects along the lines that Professor Ziegler is talking about. But another thing that came up right around when Dobbs came down, and that was detailed to some extent in Dean Rebouché's article on this, co-authored article on this, which made the rounds and I think was cited by the dissent in Dobbs, is actually, all the states are going to try to interfere with each other on this issue as well. So it's not going to be 50 flowers bloom. It's going to be 50 flowers fighting with each other. The metaphor has failed.
Angry flowers.
Yeah, angry flowers. So
New video game coming up.
but now both of you have just given obstacles to states' ability to interfere with each other. So my question is, if you can project out 10 years, so some of the unlitigated questions have been litigated and some of the open questions have been resolved, do you think there are any realistic ways in which the states will be able to interfere? Or at the end of the day, will it really be something like what was projected before? Either Congress takes it, or if it doesn't, the states are mostly governing themselves.
So I could see various ways that it would be resolved. I could imagine a view that's sort of like the view of the Middle District of Alabama judge who, in the Yellowhammer litigation recently, who said essentially there's a very strong right to travel This was the position of the United States, which had intervened in the case. I imagine that the new administration might take a different view, but that essentially no state can interfere with going across the border to do something legal in another state. I don't know that that's the only way it could be resolved. I could also imagine a very strict territoriality rule that says, look, if you're in Alabama and you do an act preparatory to something that is criminal under Alabama law, that is, aiding and abetting, whether or not the sort of actual commission of the act. So if you're in Alabama and you plan, to go to another state and use marijuana, let's say, Alabama can say, sorry, your buying a bus ticket is an overt act in furtherance of the conspiracy, et cetera, and we're going to put you in jail for that, even if marijuana is legal somewhere else. So it raises, is there an affirmative, is right to travel a sort of affirmative right that sort of covers anything that involves travel, even if it also involves something that's within Alabama and is plausibly illegal under Alabama law? So if you're going across the state lines to do a bank robbery and you buy a bus ticket, that's an overt act in furtherance of conspiracy. They can prohibit that, even though it involves travel across state lines. And so, what is the relevance of its legality elsewhere? When it comes to national borders, the doctrine is pretty much, we don't care about other countries. So if you buy a plane ticket to go do sex tourism, we're going to throw you in jail, and we don't really care that involved international commerce. Alabama can absolutely throw you in jail for that. So is there something about it being legal in another state that takes it sort of out of Alabama's ability to prescribe inside Alabama acts? So again, in summary, I'd say there's two possible ways. One is very strong right to travel, sort of everything is determined by which states allow abortion within their territory, or you could have the opposite, very strong sort of where is the person acting rule that's also territorial but in a different way. In general, when stuff like this happens and you have sort of big conflicts, there's sort of a rush to territoriality because at least those are lines. At least we know where you are and where you're acting. In general, the field of conflict of laws has sort of drifted away from territoriality over the last, 100 years or so. And, so what if you're a citizen of Alabama, but you are going to college in another state? Can they regulate you? Typically, the answer is no when it comes to criminal prohibitions, and I think that is only going to become stronger as it gets more complicated. The one exception of this is the Sciriotis sponge fishing case, which is if you go into international waters, but you're a citizen of Florida, Florida can still get you.
Good to know. Dean Rebouché.
Yeah. Note to self. So I guess what I would add is maybe something that's more tethered to the on-the-ground realities of enforcement, which was raised earlier. I don't tend to find as convincing the analogies to homicide, the Ninth Circuit case, or bank robbery, where those are actions that are illegal across the country. In the situation of shield laws, you have New York stating a very strong public policy of protecting its in-state providers from out-of-state investigation and the like, and a very clear public policy of allowing abortion through viability, et cetera. And so the reason I bring that up is because I think that those guardrails of travel and territoriality are important, but I also think that in addition to those potentially resolving some of the questions of interstate conflict, I think it is incredibly expensive to try to enforce some of these regimes because the push-pull we already see. You have New York stating through its AG and other offices that it'll defend Dr. Carpenter this, that, and the other way. And then we have Texas proposing bills, for instance, that repeat the RICO claims that Professor Sachs just mentioned that try to penalize internet providers, that create deceptive trade practices through internet sales, and all of those are measures completely within the remit of the Texas state legislature to try to stop or impede the influx of mailed medication abortion. But to actually make it happen is incredibly hard. logistically complicated, and it's the reason that there's comity between states in terms of uniform acts that permit investigation and discovery and subpoenas and everything else that have now been exceptions created in them through shield laws. They facilitate what is the less expensive, easier way to do business among states. And so, long-winded way to say there's a great piece coming out by Charlie Silver at the University of Texas that says, who's going to pay for this and when will it become too expensive? So not a completely satisfying answer, but I think a nice addendum to the nice points, the interesting and persuasive points that Professor Sachs made.
Great. Okay,
Yeah, and
my
I can add
last.
something on it.
Yeah, go ahead.
Go ahead. Sorry. I was just going to say on enforcement, one of the kind of interesting trends that's emerging in bills so far, and it's very early, obviously, I understand that, but there's been a huge embrace of civil enforcement and private enforcement in a lot of the bills that are coming out of states. In particular, sort of strict liability bills with very, very high minimum damage amounts. So, for example, a bill in Tennessee on prohibiting the mailing of abortion pills, which is, of course, already illegal in Tennessee, but authorizing a private enforcement action that would lead to a minimum of $5 million in damages per abortion, right? So I think part of the way that states are trying to circumvent these enforcement challenges is by outsourcing enforcement to private citizens, right? Biological fathers seem to be kind of the private plaintiff of choice at the moment. I don't know if that's going to continue necessarily. I mean, there's a lot of historical precedent for that in the movement, so that may continue. But that's one of the things. And frankly, that's even been true with criminal enforcement. If you think about, well, I mean, not that anyone would think about this other than me, but if you thought about how the Comstock Act was enforced, when of course you need a warrant to open people's mail and there would be no ready way to identify if abortion pills are being mailed, it relied heavily either on sort of what we would today think of as catfishing, right? People posing as people seeking abortion medication or contraception. And it also involved a lot of private-public partnerships, right? Private citizens informing postal inspectors, private citizens doing their own investigations because they were upset an abortion had occurred or because they were upset someone had received abortion-related advertising. So I think it's important, if we're starting to think about enforcement, to understand that there will be lots of non-government actors in the picture, and that when government actors are in the picture, it may proceed the way it did when the Comstock Act was sort of at its peak, or when enforcement was more common than it's become in recent years.
One thought, actually, I mean, I don't think there's any appetite for revising the Comstock Act in any way whatsoever, because I can't imagine anything that would get 60 votes. But one possibility would be a revision of the Comstock Act that would apply only to use of the mails into a state in which abortion is prohibited. It's sort of like a 21st Amendment Section 2 kind of idea, that you would allow, the idea would be that a state that wants to prohibit abortion can keep products out of its state, but that we're not going to prohibit, stuff going on outside those state borders. Again, I could imagine that some sort of territorial compromise along those lines.
Yeah, it would be interesting because I think holding the possibility that, I'm not sure I agree with Jonathan Mitchell's interpretation of the Comstock Act, but if one does, it doesn't include any exceptions either. So another interesting feature of the kind of territorial compromise that Professor Sachs is describing is that it would better track what states that prohibit abortion currently do, right? There is no life exception in Jonathan Mitchell's interpretation of the Comstock Act, for example, which is not something that a lot of states would currently countenance. To my knowledge, any state would currently countenance, although there are some states that have affirmative defenses as opposed to exceptions. They all have some kind of life protection. So it's true that the Comstock Act is sort of an imperfect vehicle even for people who want to prohibit abortion, because if you interpret it the way some conservatives have, it doesn't track what states are trying to accomplish today.
Okay, well, we have a little over 20 minutes for questions, so I'm going to stop with mine at this stage and see what any of you have. Yes, sir.
For those of us who are not partisans in the abortion wars, what's really interesting about this panel is the issue of how a federal system deals with conflicts between states. And I'm wondering if any of you have looked carefully at the past history of such things. That the most recent one that occurs to me would be the issue of Reno divorces. And I don't know whether there were any anti-divorce activists who tried to find ways around full faith and credit, ways of getting their state to not recognize a Reno divorce. The obvious early cases would be the pre-Civil War issues over slavery, which were really the most similar in the sense you had people with strong, passionate feelings about what other states were doing. And I don't know what legal devices were tried. Obviously, in some cases, you've got federal law which prevents the conflict. I'm thinking of the marijuana situation at the moment, where as long as marijuana is federally illegal, it's presumably not an issue of one state trying to subvert the neighbor state's prohibition on marijuana. But have you looked at the general history of the issue of which this is just one special case?
Mm-hmm.
So I would say that actually the most recent case of this was same-sex marriage, because Obergefell was if I'm remembering the fact pattern right, it was a marriage on a tarmac in Maryland. Is that right? And so it was by non-Maryland citizens. So it's all of those cases were conflicts cases. The Defense of Marriage Act before its repeal was Section 2 was a conflicts question. What do we do about recognition? So whenever you have big, important disagreements between states, it immediately becomes a conflicts question, because people outside that state will want that policy too, whichever direction it is. In some cases, it's easy to sort of territorialize it and say, okay, well, you're in that state and it's fine, but you go out of that state and it's not fine. So the regime under same-sex marriage was pre-DOMA that it was up to, and even post-DOMA, it was sort of up to every state to decide whether it wanted to recognize. So you could be married in Hawaii, but not in Texas. That is still the rule for things like first cousin marriages, which some states permit and some states will recognize, even though they don't permit it, and some states won't recognize them at all. So you can have couples that can move from state to state, and whether they're married or not changes depending on where they go. Before that, the divorce cases were primarily in the 50s and 60s with like divisible divorce, where they'd say that sort of one state can say, yes, you're divorced, whereas another state says, no, you're not. That's when Justice Jackson said, if there's one thing people are entitled to expect from their lawmakers, it's knowing whether they're married and if so, to whom. That still the law is that can change, state to state depending. Before then, it was guest statutes and whether passengers could sue drivers in cars depending on which state they were in. And then you go further back and you get different cases. Ultimately, leading up to slavery, which is the main conflicts question that the Fugitive Slave Acts did not entirely solve in more ways than one.
I would tack on that, in probably every family like course, you teach a case like May, which is the first cousin case that you just referred to, which is you may be married in Rhode Island, but New York, for public policy reasons, doesn't have to accept that you're married for the purposes of New York law. To your point about divorce and that being a generative example, and I use that example too to just say that there are lots of analogies that people are thinking through, some more fraught than others, but this idea of the making an argument for or against state sovereignty, for or against extraterritoriality, it's going to flip. So, your nightmare could be someone's dream, your dream is someone's nightmare, but, those arguments, for instance, could also be employed to uphold or to cut against the abortion trafficking laws that we didn't get a chance to really talk about. And so I appreciate the point very much, because there's no partisan silver bullet to the question of these conflicts.
And we have Jonathan Adler in the audience, but I would think that marijuana federalism would be a good example of a situation where states have different policies. it's sort of not crazy that they would have either policy A or policy B. It's not like a state that licensed bank robbery. Like, we understand that there are disagreements here, but questions about what happens when someone plans to go from state A to state B to make use of the laws there, is that something state A can do something about, would be very much live.
Other questions? Yes, sir.
Steve, just a simple question, but if Carpenter was in a non-shield state, to what degree, how much more vulnerable would she be in Texas outreaching to her?
So even the non-shield state might not enforce the penal judgment. Most states usually don't, but it's up to them. So it would depend on their own laws. If she were in a non-shield state, though, they would help with discovery. So if you needed to serve a subpoena on somebody and make them testify and things like that, a non-shield state might, have an officer show up to make them go to the deposition and so on, whereas a shield state would not. One issue, and maybe this is again a question for some of the audience, it didn't occur to me beforehand, but I wonder whether Texas, if it wanted to, could litigate in federal court and get federal discovery advantages and so on if it made a federal common law nuisance claim. Because it would say, like, look, we've got our unauthorized practice of law, our unauthorized practice of medicine, people are violating it, it's going across the border and so on. It's maybe a stronger claim than, you're emitting carbon dioxide somewhere. And so, I wonder, because that's how states have tried to sue citizens of other states with original jurisdiction in district court in cases like the Milwaukee case. And I don't know if they could try doing it here.
I would just tack on, too, that it's interesting the posture, the way this was taken and the timing it was taken, because all shield laws have exceptions for conduct or actions outside that are contrary to other laws of the state or that sound in tort or contract. And so I always expected the first suit would be a negligence claim or outside scope of practice or practicing without a license, which you can't do in New York. So it's against the laws of New York to practice without a license in another state. And so maybe I shouldn't have said that.
One other thought is on the clawback provisions. I wonder if Texas could seek declaratory relief in Collins County for a ruling that the clawback provisions don't apply as a choice of law matter, and the Texas courts would decide that as a matter of Texas choice of law, and I think that would be effective then to protect Texas, officers, agents, employees, et cetera, against litigation elsewhere. Even if the penal judgment is not enforceable, this would be declaratory relief, so it would be a different kind of judgment, and maybe it would have full faith and credit effect.
But you'd still have the enforcement problem, and then you might have like dueling default. So, New York says, well, we don't recognize that you've issued that declaration. We're not going to enforce it. In fact, we're going to
they would get full faith and credit protection.
and then that would be.
That they could go to the feds for, yeah.
Yes, sir.
Hi, I'm Jeremy Tellman from Oklahoma City University. I had a question for Stephanie, and I'm uncertain about your argument and the fact and the law, but I'll try. So I think in the Indiana case, your argument that the strict scrutiny, that Indiana has a strict scrutiny, an interest that will survive strict scrutiny, turns on Indiana having determined that the state has a compelling interest in the life of an unborn child, of a fetus. So I thought that's an interesting, I think it might be an interesting situation in that some states would assert a compelling interest in the life of a fetus and other states wouldn't. Are there many cases like that where a compelling interest would vary from state to state? And then also, what would happen if, for whatever reason, Indiana decides to change its policy because they haven't really thought through all of the implications of basically recognizing fetal personhood, and they decide, like, we need to back away, and then what would become of your argument?
Yeah, so just to clarify, I'm not saying that Indiana gets to say we have a compelling interest in this thing because we said so in our law. So there. The issue is that, major premise number one, the Supreme Court has said that protecting a human life is a compelling government interest. Then the next premise is, and the Supreme Court has now said after Dobbs, that states can define a human life as beginning at conception. And Indiana has done that. So they have taken advantage of that opportunity. They've now passed a law saying, we define human life as beginning with conception with some minor exemptions. So I think one of your questions is, what if they change their mind? What if they decide that they don't want to do that anymore? Also, do we have situations where states don't enforce laws uniformly? I think the answer to the question about changing your mind is states do that, not infrequently. So in Holt versus Hobbs, the prison in that case, I think it was Arkansas, had said that they just couldn't allow beards to be offered to prisoners because there would be all sorts of security issues and people could hide weapons in their beards and it'd be bad. And after the Supreme Court did say that this particular prisoner could have an exemption, they just changed the policy across the board and said everybody can have a beard. It doesn't have to be for religious reasons. So the fact that a state can enforce something and could have a compelling interest in something doesn't mean that they must defend that compelling interest. Certainly doesn't mean that they must defend it at all costs. So think about states that allow for assisted suicide, like Oregon. Lots of states don't do that. That doesn't mean that Oregon couldn't still claim a compelling interest in defending human life in other sorts of contexts. It doesn't mean that because they allow for assisted suicide, they have forfeited their right to defend human life anywhere else. Now, it might be the case that if Oregon only protected human life when it was Aztec religious sacrifice, and they didn't care about human life anywhere else, then we'd say, I don't know, that seems like pretext, like you're pretty much the Wild West outside of that. And there have been cases where it seems like the government is only regulating an interest in one particular context that looks gerrymandered. Outside of that context, we don't require states to advance a compelling interest with perfect uniformity in order for it to be a compelling interest. But if there's a lack of uniformity, what Professor Laycock has argued and Rick and I argued in our amicus brief is the lack of uniformity sometimes and often is evidence that there are ways that the government can both advance the compelling interest and protect the First Amendment right. And this is just one of the unique cases where the parties, the plaintiffs, have conceded there is no less restrictive means for you to protect these human lives. You have a compelling interest in protecting these human lives. We have a religious exercise that would kill these human lives. And so we have joined issue. There's not any debate about whether there's another way to protect those lives.
Yeah, and I'd quickly add that I don't think what's happening in Indiana is necessarily full-blown personhood either, right? I mean, having a compelling interest in protecting human life, I think you probably should disaggregate from recognizing that particular human life as a rights-holding person in one context or another. So, you know, I think one of the premises of the question was, well, what if a state embraces fetal personhood and has buyer's remorse because of some unintended consequences? I think it's important to say that the status of state laws prohibiting abortion, even those that invoke interests in protecting life from conception, and sometimes with some sort of constitutional adjacent language in their preambles, are not clearly all personhood laws, right? So that's one of the reasons, for example, that Alabama has a state constitutional amendment that can be understood as a personhood amendment, and its precise enforceability and in what context is very much underdetermined. So I think if we're trying to kind of get at where these laws are going, it's important to sort of to disaggregate those things.
It is a bundle of sticks. Professor Adler.
Not a question about marijuana federalism, although happy to talk about that. I have some questions about, I guess, how to think about preemption, FDA preemption in this context, and the way that might interact actually with things like standing. So on the preemption side, it seems most of the focus thus far has been thinking about these questions just in terms of pure FDA preemption, what do Wyeth, et cetera, mean for this sort of context. But it seems there's a separate angle that states can take, which is to say we're not, the issue is not can we prohibit the sale of a product or a particular medication. The question is, in our exercise of our police power to regulate the practice of medicine, can we prohibit a procedure? And we don't care what it is you use for that procedure, because it's the procedure that's prohibited, right? So a state's ability to regulate a medical procedure might not be dependent upon its ability to prohibit the sale of the instruments used for that procedure, because what it is prohibiting is that aspect of the practice of medicine. So the first question, I guess, is that a pretty strong argument around any concerns about FDA preemption of the state's ability to prohibit, say, mifepristone? And then if it is, does that undercut state arguments for standing to challenge the approval of mifepristone? Because it seems to me the strongest arguments states can make as litigants to try and challenge the FDA's approval of mifepristone is that they are either directly or indirectly obligated to provide for mifepristone through state insurance programs and the like. And I think they would argue that even though mifepristone is less expensive than live birth, that the state could arguably assert interests that are not about the amount of money expended. But if the state has the ability to prevent the use of that medication within its borders for that purpose, then it has the ability to eliminate the injury that it is complaining of. So I'm curious if folks have thoughts about those two tentative observations.
Yeah, I think the preemption argument's a tough one, and I mean, I happen to agree with you. I think that so my co-authors and I have written pretty extensively about preemption, trying to figure out, is there an argument to make for states for preemption on the behalf of the FDA, and in terms of creating either windows in which certain uses of mifepristone for certain conditions or through certain mediums like telehealth, there is a preemption argument because the FDA has acted, or should there be mifepristone access according to the FDA's REMS? And I think the practice of, I'll just be very candid, I think the practice of medicine argument's a very strong one and a very strong distinction, and I do think it undercuts standing, because I think that all states that ban abortion are operating under the assumption that they are not preempted from banning mifepristone and all medication abortion, whatever the means, within their borders. I think that you know well the cases that have chipped away at that in pieces. But I think that there is kind of a reverse logic there of what comes next if that preemption does indeed exist. And in fact, it really gets at the heart of some of the alliance litigation where you have, for instance, Rice, you have another court that has said the kind of mirror image of what the district court said in Alliance, which is, the REMS are the REMS and they freeze. We're not going to repeal them. We're not going to lift as a court REMS that we might agree are not necessary for safety or efficacy, but the FDA is the FDA, and we freeze that regulation as it is. Well, that also cuts for and against preemption arguments in really interesting ways. So just a long-winded answer to say yes and.
If, when all of the legal issues are resolved, it turns out that New York is indeed free to mail abortion drugs into Texas, does it also follow that Oregon is free to mail suicide kits into other states?
I would think that the arguments are identical.
That's what it looks like.
Which is why, I mean, to me that seems like a reductio.
Yeah.
Anybody else? Any final thoughts from the panelists? Please join me in thanking our panel.